All right, hello everyone, and welcome to our latest Alta Insights webinar. I'm Jeremy Yohe, Alta's Vice President of Communications, and today we've got a great presentation that will discuss, essentially how to build a compliant affiliated business. Our expert speakers will offer insight from compliance and operational perspectives, and dig into some of the core and non-core title services that you should be thinking about. We've got a few housekeeping items to go over before starting. Today's webinar is being recorded. You'll get an email with a link to the recording tomorrow, and you can always access all of our webinar recordings at alta.org/webinars. The email will also include a link to download a copy of today's presentation. But anytime you have a question, please submit them through the questions box. We'll hold a little bit of time at the end for Q&A. As a reminder, this webinar is for educational purposes only. You should consult counsel for any legal advice. Today's webinar does offer CE and CLE credit for many states. We've got some important information about this, so pay attention. Credit's only available for those attending this live presentation. To meet state compliance, we're going to have a couple of poll questions to make sure you're paying attention. At the end of the presentation, I'll post a link in the chat box so you can submit information needed for us to report your credit. Let's see, the link will be active for 72 hours after the webinar, and to ensure you receive credit, add or update your national producer number and license or bar numbers in states where you're requesting credit. And then check the attendance certification box and click request credits. Let's see, if you're not requesting credits, a non-credit certificate of attendance is available for print or download. Just note that this certificate cannot be used for self-reporting. And if you miss a 72-hour window and the link is closed, just email education@alta.org and we'll help you out. All right. I need to thank RamQuest for sponsoring today's webinar, and we have a short message from RamQuest.
At RamQuest, we foster a customer-first culture built around our core values and our unwavering commitment to provide solutions that don't just meet but exceed expectations. Our newest title and settlement production solution, Horizon, delivers unparalleled efficiency, robust features, and scalability to ensure you have tools to boost productivity and elevate performance like never before. It streamlines your operation with secure 24/7 access, automatic updates, and all the power only the cloud can offer. Plus, Horizon offers a direct connection to the industry's most extensive network of service providers and partners. So, if it's title and settlement related and you need it, we've got it. Experience more at ramquest.com.
All right, thank you, RamQuest. Let me get the presentation back up here. All right, now I can introduce today's speakers. Here we go. All right, joining us, we have Trip Riley. Trip is partner of the law firm Sal Ewing. He is co-chair of the law firm's Consumer Financial Services Litigation Group, which represents clients who are facing various complex civil litigation. Also joining us is Aaron Davis. Aaron is CEO of the Florida Agency Network, which is a conglomerate of independent title agencies that share back office services and other pooled resources and technology. Aaron and Trip gave a different version of this presentation on Alta One last year, and wanted to give this important information, make it available to a wider range of professionals in the industry. Aaron and Trip, thanks for joining us today and sharing your expertise on affiliated businesses. And Trip, I will turn it over to you.
Thanks, Jeremy. Really great to be here today. Yeah, I think that the Ulta One was such a success. I know I had gotten phone calls over and over again after Ulta One, so I'm glad that we can do this on an even greater, somewhat greater scale today. So thank you to all the attendees who are here. I know that there are a few on listening that I know and that we're friends and maybe even clients. So I'd thank you for also attending. And I just wanted, before I begin, I want to do a shout out to Holly Bunting, who may or may not be attending, and thank her for these slides. She and I have used these slides before, and they were such a great resource that I thought I would use them again. So again, thank you, Holly. So we're here today to talk about exclusively affiliated businesses or joint ventures. And how you can create an affiliated business. And in this instance, obviously, we're talking about a joint venture title agency, but it equally applies to a joint venture mortgage company, a joint venture property and casualty, a joint venture home warranty company. But before we jump into the affiliated business compliance, specifically, we need to set some context. And the context in most states is RESPA. RESPA is the regulation that, among other things, regulates what type of fees can and cannot be provided, or consideration that can be provided within the settlement service industry. And in particular, Section 8A, which is a precursor to not a precursor, but it sits above 8C4, which deals with affiliated businesses, is 8A. And 8A, for those who don't know, basically says that no thing of value can be given or promised or agreed to, and nor can any consideration be accepted for the referral of settlement services. And so prior to 1983, affiliated businesses were unlawful. And why were they unlawful? Well, because the whole notion behind affiliated businesses or joint ventures are that the owners of those companies, either in whole or in part, are referral sources. And so the money that was being paid as profit out of these companies to the investors who are referral sources were considered a thing of value and therefore a kickback under 8A. As well, you could go a little more granular and you could say that actually the offering of an investment opportunity in an affiliated business or joint venture was an offer of a thing of value for expected referrals. But in 1983, RESPA was amended. And it's important to, again, understand that context, that when that statute, which from its inception was no thing of value can be given or received for the referral of settlement services, the promulgation of 8C4 has to be understood underneath that prohibition. 8C4 is an exception to that. That means that the things that are happening with an affiliated business are an exception to 8A. So the two things to think about in that sense, the first one is obvious. The payment of distributions from a company to its investors, even though those investors are referring business to the company, will not be viewed as a kickback or as a referral fee. Equally, the fact that you're offering an investment to a referral source in return for some expectation that they will refer business to that company is not a thing of value. And I think we'll talk a little bit about how that issue, that question, has gotten lost in the discussion and the review of affiliated businesses by some states. But in order for those distributions not to be considered a thing of value, that payment to referral sources, you have to meet a three-part test. Next slide. And we'll talk about that three-part test in a second. In 1992, Reg X addressed more specifically affiliated businesses. In particular, it noted that if a investor, let's say a real estate company, its owners or the real estate company itself that are referring business to the joint venture, if they have an employee, they can who is attempting to get agents to refer business or anyone else to referral business, they can be compensated based upon capture rate, and that's not a violation of 8A. So if you have an office manager, you have some sort of employee whose whole role is to interact with agents and try to have them refer business to the company's joint venture or affiliated business, and you pay them in whole or in part on the capture rate, that is not a violation of RESPA. More importantly, or equally importantly, those type of companies can also offer discounts and rebates to consumers for using the affiliated business. The typical one there is where a builder has a title agency, affiliated title agency, either a wholly owned subsidiary or a joint venture with a title agency or an underwriter. That builder can offer discounts, rebates, upgrades if the consumer, the buyer, uses the joint venture, and that is not considered a violation of RESPA. So you can see how the affiliated businesses do give advantages to some of its members. Next slide. So under 8C4, there were concerns by HUD as to how this affiliated businesses were sort of evolving. And they issued what has been commonly called the HUD 10-part test, where they went outside of what the statute requires, and they didn't promulgate any regulations to this part in this regard. But what they said is, we have this 10-part test, and it's going to tell us whether or not the affiliated business is actually a sham and therefore should not be able to take advantage of the 8C4 exception. Now, we all know, who have been in the industry a long time, that it wasn't you had to be compliant with every single 10-part test. Sometimes it was, well, you're compliant with 7 and you're doing okay on the rest, and therefore you're okay. It was really, really subjective, both HUD and the CFPB, the way they applied those factors, and sometimes they weighted some more important than others, depending on who they were looking at, who they were investigating. And I'll tell you that, as the slide indicates, that just last year in September, the CFPB said it's going to continue to follow that 10-part test policy statement. Now, they've done that even though, as you see here, the Carter-Wells-Bowen case, which was 10 years earlier, the Sixth Circuit, which encompasses Kentucky, Michigan, Ohio, and Tennessee, said that the CFPB could not use that 10-part test for enforcement purposes. I won't bore you with the analysis, but basically that means that the CFPB, if they are looking at affiliated businesses in those states, can't use any deficiencies in that test or in those elements to determine that the affiliated business does not or should not receive the safe harbor under 8C4. So next slide. and the question is whether when they have now announced that they are continuing to follow the 10-part test, how they're going to do that, given the Sixth Circuit's decision. Clearly, that decision is not in place in any of the other circuits. But certainly, if they were to if the Bureau was to challenge an affiliated business, let's say in California, or in more risky for them in the Fifth Circuit, Texas, Mississippi, Alabama, how would they be able to enforce that? Given that it is likely that the district courts and the circuit courts would follow the Carter-Wells-Bowen case. So we'll have to see if that happens, as now there hasn't been any RESPA enforcement actions by the CFPB where they have or attempting to use the 10-part test to deny an affiliated business and its partners from the benefit of 8C4, but we'll have to wait and see. And of course, they certainly had the opportunity to do that. In this case, Borders versus Borders, which was actually after the Carter-Wells-Bowen case, also in Kentucky, the initial attack on the affiliated business was, as you see here, there were 9 affiliated businesses and there were no employees. The only person that was providing any services related to or allegedly related to the affiliated businesses was a person employed by Borders and Borders, which is a law firm. There were no offices, no disclosures were, the disclosures as the affiliated business disclosures, which we'll talk about in a second, weren't handed out until the closing table. So when the referral happened, the disclosures weren't given. They were just given at a time where it didn't really matter anymore. But the district court judge in that case basically said, look, all that affiliated business has to do is follow the 3-part test that's in 8C4. That's it, because there's nothing else in the regulations. We can't apply the 10-part test at all, even though by all accounts these were just shell companies that did nothing except funnel money based upon the referrals to the Border and Borders companies. So, there's no other district court that has taken this up, but we can see the sort of the push and pull here, where we have judges or a judge that says, look, I'm reading the statute. The statute says meet these 3-part tests, and that's all you have to do. And then you have the CFPB saying, no, in every jurisdiction other than the Sixth Circuit, we're going to continue to root out what we call sham affiliated businesses based upon the 10-part test. That is, setting up an extreme gray area. Next slide. So what is the 3-part test that allows the distributions from an affiliated business not to be viewed or treated as a kickback? They are that you have to disclose to the consumer on a separate sheet of paper the identity of the affiliated relationship. So for example, a real estate company, it has to hand out an affiliated business that says either the real estate company has an ownership interest, the owners have an ownership interest, direct or indirect. Certain agents may have an affiliate, maybe investors, so they have to hand out the affiliated business that identifies their interest, and they have to do it at or around or close to the actual referral. So typically that will happen way before the closing, because the customer needs to choose a title company at the get-go. So that's when that affiliated business should be provided. And I know that Aaron will talk about how he does that, how he makes sure that his affiliated business disclosures are going out, or his partner's affiliated business disclosures are going out at the appropriate time. Second, the investors or the referral source cannot require that their customers use the affiliated business. And then third, all of the returns, all of the distributions can only be based upon the ownership interest of the investors. That means the payments can't vary based upon referrals or capture rate. You can't take away interest because a certain investor hasn't performed as you expected. And you really shouldn't give more, not give, but allow investors to purchase more shares based solely upon their performance. It's not completely impermissible, but you really should consult with your attorney about how to set that up if that's what you want to do. Next slide. All right. Even though we talked about how, at least in the Sixth Circuit, the 10-part test can't be used, nonetheless, I know I tell my clients to follow it just to avoid the risk, and I'm sure Aaron is going to tell you he does the same thing. So what are they? Capitalization. That means they need the joint venture needs to be fully capitalized. What does that mean? In my book, what that means is you got to look at what it costs to start the company and stand it up and then run it as if no revenue was coming in for 6 to 9 months. Who pays the capital? The investors pay the capital. How much do they pay? They pay based upon their ownership interest. I also know that a number of my clients, and I think there's nothing wrong with this, has also capital reserves. So, well, some of that initial capital may not be used and will become reserves. A number of my clients say, I want to put another $30,000 into a capital reserve because I don't know what's going to happen down the road. That is a smart decision. It's not required, but it is certainly a smart and risk-adverse decision. The joint venture needs to have a dedicated employee who is and again, in the title joint venture, a licensed title producer who will be performing the core title services and overseeing either the employees or the support staff that may be from another company, from your partner, overseeing the material aspects of core title service or the support of core title services. You know, making sure that the reader has read appropriately, making sure that clearance has happened appropriately. And so that's at a minimum. That's at a minimum. I would suggest to you that the goal should be a joint venture that operates like any other title agency with full processors and other administrative staff. The other ones are relatively straightforward. Should have its own office, its own entry, its own signage, its own phone numbers, websites, its own, or at least a sub-license on the title production software. It should have a manager, and so that licensed title producer can be the manager. If not, it should have its own manager that's making decisions for the company. It can contract out services. So that means that in a title joint venture, the title partner, that is the owner of the existing title agency, who's the partner, can provide certain administrative services. It certainly can provide HR, accounting, vendor management, lease, negotiations, things of that nature. But they can also contract out for certain processing. Again, order taking, perhaps even some closing and post-closing services, dealing with the escrow. But if you're going to have your title partner provide those, if the title partner is going to provide those services, it has to be at fair market value. It can't subsidize, it can't provide those services for free of charge or at some subsidized amount. It has to get paid by the joint venture fair market value for the services that are rendered. And I always say it should be pursuant to an agreement. We call it the administrative services agreement. Some people call it a management services agreement. But in any event, always document that so you can show the regulators that there is an agreement and where the pricing and so forth is. It should do its own marketing, and it really should look beyond its referral source investors for business. And that's important in this, not only generally, but also important in those states that have controlled business limitations. Many states, Ohio, California, Utah, Washington, Tennessee, Louisiana, and others, only allow title agencies to receive somewhere between, and this is just an aggregate, 50 to 70% of business from their owners. So that means you have to get the other 30% or 40% from outside or from other sources than your investors. I wouldn't say that, and I would say, however, that the investors in these joint ventures can only be referral sources. There is, and we'll talk a little bit about it, there is some pushback on that by some state regulators, but I think they're wrong in that regard. Next slide. So this is just to hit on a few things that both HUD and the CFPB looked at to try to argue that the affiliated business at question should not receive the safe harbor under 8C4. And so these are sort of self-explanatory based upon the rules, but we've seen joint ventures where the investors are getting paid not based on their ownership interest, but on referrals or capture rates. It's gone up and down. There's some joint ventures out there where the investor loses some or all of their interest if they don't hit certain targets. All of that is just not wise whatsoever. Other ones where there's no employees, there's no own office space, and certainly there's always a problem when the affiliated business disclosure is not provided. Now, Reg X, which is the regulation promulgated to achieve some of the RESPA requirements, it does allow for inadvertently handing out the disclosures. Inadvertent, you got to prove that you had a track record of doing it and something fell through the cracks. And it has to be below 10%, I would say, for any regulator to say that it was inadvertent. The other thing is you don't want to put, as you see the last item there, putting the affiliated business on the contract of sale or in the MLS. It looks too much like a required use. You may argue it's not. You're just suggesting, but I would tell you that that's a bad idea. Just from the track record of dealing with these. Next slide. So even though you may have a RESPA compliant joint venture, there is still issues at the state level. There is really no state statute that says, one, you can't induce the purchase or you can't provide a rebate for the use of or engagement of a title agency. I mean, they say that, but they don't say anything about what about affiliated businesses? Is an affiliated business, does that run afoul of the anti-inducement law? I haven't seen any state say that, and there's always someone who suggests, isn't that a problem? I would say that the states know they exist, and if they really thought it was running afoul of anti-inducement or anti-rebates, they would have done something by now. Some of the other problematic areas, just having one real estate agent or fucking kidding me.
Trip, I still see you. I can still see you. Can you hear me?
Good. Yeah, I'm sorry. It's my laptop sort of seemed to have disappeared, but here we go. All right. And sorry for that slip of the tongue. Anyway,
I could take this whole thing over if you need me to, Trip. I'm here for your. I'm here for your.
I'm just getting. My firm decided that they wanted to install something on my laptop like right now. Anyway, so one of the problematic areas that I wanted to just is to have a quote joint venture or affiliated business with just one referral source, like one agent or a team of agents, it's difficult to, number one, achieve any control business limitations thresholds. It's hard to do that. So, and among other things. So I would stay away from those, and I'm sure that Aaron can tell you from his own track record why, or experience, why that is. And some of the other areas, I guess I'll just address them here. There are two jurisdictions, one District of Columbia and the other one Pennsylvania, who seem to be taking the position that initial capital that you would have your investors pay, maybe they own, maybe each one owns 2%, that equate up to 50% or something along those lines. They seem to be suggesting that those individual investors, like agents or loan officers, need to pay more for their units than just their pro rata share of the capital needed to start the company and run it for 6 to 9 months. I can tell you, I completely disagree with that. There is nothing in the statute that says that investment dollars need to reflect some future earnings, what that projection is. And quite frankly, it's weird because one year the projections could be, $5,000 a year, and the next year the projections could be 20,000, and then in today's market it could be zero. So it doesn't make much sense there. But they are sort of pushing that concept, and I'm involved in both investigations, one in DC and one in Pennsylvania, where we're butting heads on that. And the other thing that they're looking at is how you make a decision who your investors are. And again, their position is there should be investors that are. Why aren't you having investors who are not referral sources? Why are you only focusing on agents that have large books of business? And the response, at least for me initially, for my clients, is, well, who else would I want to be partners in the company? And by the way, there's nothing in RESPA, there's nothing in the regs, there's nothing in policy statements by either state or federal entities that says I can't do that. So, I just want to highlight the push that we're getting from those two jurisdictions and perhaps others in the future, that they're looking at the decisions about who your investors are going to be. Next slide. So I'm told that in order to get CLE and CE credit, you're going to need to do this poll, and there'll be one more coming up.
Yep, quick poll question. Can a title company give a borrower an incentive such as a chance to win a trip or a rebate for doing business with the title company? Give you a few more seconds. Trip, about a little less than 70% say no. We've got 18% that say depends. We'll go ahead and close it. So I'm thinking the depends might be on the right track.
Well, in fact, the incentive to consumers generally is not a problem. However, of course, in a title company, that could be considered an inducement or a rebate under state law, not so much a RESPA violation. I always suggest that if that's a thing you want to do to try to get business, it should be your partner in the joint venture, the non-title company partner, who's providing that incentive. For example, a real estate company may agree to reduce the borrower commission at the onset if the buyer borrower agrees to use the title company. It's no different than the home builder offering an incentive for the buyer to use the title or mortgage company to which the builder is affiliated. So this is just another a short slide that you can take it for what it is when you look at these later. We already went over the sort of both the 10-part test and the statutory requirements. You know, we talked about investment capital, talked about a dedicated employee. And very important, again, is the core title services. And I know Aaron will talk about how he manages that, his joint ventures with an employee who's a licensed title producer, who's providing the core title services, but also having to oversee those who are providing the support. Next slide. So that's the end of my presentation. I think that, again, the takeaway from that is these joint ventures are completely permissible. There's a way to create them, which I just went over, just sort of the regulatory ways to create them, to maintain them, to operate them. There is some strangeness now in a few states. They're looking for ways in which to get underneath and sort of pressure affiliated businesses either out of the market or to reform. You know, if you stay tuned to either my Twitter or to my LinkedIn site, I've been reporting on that as well. So I'm going to turn it over to Aaron, who has really valuable sort of day-to-day operational guidance for you.
Thanks, Trip. And when you mentioned those the non-real estate investors, I just went to my head. If I'm opening up a steakhouse, I'm probably not inviting a bunch of vegetarians to be a part of the ownership group because they may or may not support the eating of the steak. So same goes in a title agency. I think I want people who are going to be able to support the agency. Everyone, my name is Aaron Davis. I'm the CEO of Florida Agency Network, as well as a few other ancillary companies, including Closing Suite, which is actually our consulting company that we consult on systems, scale, and setup of JV operations, title operations in general. So just for a high-level overview, our network, Florida Agency Network, was independent operations that were actually started by my mother 40 years ago this year. Happy anniversary, Mom. I took over operations back in 2008. We then scaled the business via acquisitions, affiliated businesses, et cetera. So imagine a geography of 40 title offices, independent and joint venture operations, all running similarly, and then you start to pull back some of the core and non-core title services into a back office so that you can become more efficient. So I'm talking from a setup standpoint on centralized services, on how you can best set up and operate your title agency, as well as your workflows from an agency standpoint and a file level standpoint. So that's kind of high level there. And just to reiterate what Tripp said already, yes, we set up the JV title operations, make sure they comply with the 10-point test. All of our operations, we say make sure that they can stand on their own 2 feet. So if a regulator walks into your office, are they going to see a fully functioning title operation? So that includes licensed title agent, as well as 1, 2, 10 employees, however many it takes. On the setup of the joint venture operation, we're talking pro formas, proper capitalization, and in most cases, anywhere from startup costs to 6 months of capital expense. So if it takes you $20,000 a month to operate a title company, plus $20,000 of startup expense, which that's going to include your lease, your E&O, cybersecurity policy or cyber policies, et cetera. So you've got the startup plus, you want to have a runway of cash in order to be able to operate your title company. So that is typically your capitalization. Then you've got your operating agreements, your ABA disclosures, licensing, selection of underwriting, equity splits, benefits to the employees, et cetera. So our leadership team has been involved with the setup of well over 100 joint ventures, either set up, structured, or operated them ourselves. So next slide. So I took a stab at definition of core versus non-core, because as with technology, those lines become more and more blurred. And as Tripp mentioned too, as we get into some of these now discussions at state versus federal level and differences of opinion as to how a title operation should work, they become even more blurred. What can and can't be done. So I took a stab at this, and I used ChatGPT so that I cannot get in trouble for the definition from core versus non-core. So using AI, core services, which I'm surprised is actually a very good definition from our friends at OpenAI. The title searches, examination, policies, and closing and escrow services are all part of core services. And then non-core are the things that you can sub out. So when we take a look at searches, you obtain those from an abstracting firm or from an underwriter, but the examination of those searches happens at the title agency level. So therefore, that needs to happen at the joint venture title agency level as well, as that employee or employees need to be performing those functions. They need to be issuing the title policies and involved in the closing and escrow services. And again, that line can be blurred a little bit because now we're getting into a world of AI, technology, workflow automation, etc. So for my purposes, again, I want to be bulletproof. And if a regulator walks into any of our operations, is what are we doing as a title company that is federally or state required, and then what is it that I can sub out in a normal business sense. Next slide. So and a definition that I use, I like Tripp's definition, is fulfilling the duties that your title license requires. So in order for you to be a licensed title agent and issue a policy, there are certain duties that you have to do. This is an example of non-core services, things that can be subbed out. So again, this is at your title agency level, and then let's say that your agency spins off a JV and then maybe multiple JVs. These are all examples of non-core that don't have to be done at the JV level. So data entry, so your licensed title agent does not have to type in an order. That is something that can be subbed out. Traditionally, that's been something that's subbed out to, let's say, the receptionist or whoever's at your front desk is who's typing the orders. Or if you're in a centralized environment, that's someone in the back office that's putting in that information for you. Or as you grow more sophisticated and your title production software allows, you can actually utilize AI. Is now there are AI tools to allow for automated data entry, which is something that we do. File communication. So now we're getting into a world. In the past, it was our agents picking up the phone and talking to clients. And now it went from talking to clients to email to clients to portal communication, and now text back and forth. But now even the communication via text oftentimes is now an AI service. So you actually have file level communications flowing in and out that a human is no longer doing. It is now being replaced by a bot or AI to communicate. Title curative, I say kind of generically title curative. So the obtaining of things on a commitment in order to perform the closing. That's HOAs and payoffs and ordering of surveys. All of those things, again, that's something that your company right now can outsource. So it's not something that the title JV necessarily has to do on a day-to-day. Same goes for post-closing services. So once that file is closed, there are companies out there who will take that post-close file and scan it and ship it and cut the checks and pay the vendors, and then send off the packages and do all of the post-closing services. So again, an example of core versus non-core. And then finally, the talking through of a closing. The talking through of a closing is something that has been routinely done, subbed out to a third party for years and years via a mobile closer, a mobile notary, or now in the digital world, a RON closing. So in our environment, what I stress to the agents who are looking to get into a joint venture is that you're looking to not cause added stress to your existing organization, and to make things as easy as possible in order to grow the operation or to scale it. So what can happen is if you start at an entity and now you need to service, say it's a real estate brokerage, and that real estate brokerage has 10 different offices. So you have to be able to scale that joint venture or that ABA title company to be able to service all of those different branch locations. So you don't want to have in that scenario, you don't want to have a person at every single branch doing post-closing activity. You don't want to have a person at every single branch doing order entry. You want to be able to scale and grow this and properly do things in a back office or an outsourced environment. The benefits of doing it this way. Oh, next slide. Yeah, so the benefits of either partnering with an outsourced provider or doing it yourself in a back office environment is you eliminate some of the staffing challenges, because when you are, in today's world, if you're just doing it in the traditional manner, then you have, highly skilled and trained and compensated licensed title agents, closers, or escrow officers. But a lot of those folks may be doing more duties than what's truly needed by them. They may not necessarily need to be doing, in some title offices, the closer still post-closes the file. The closer still talks through the closing. The closer still handles some of the post-closing duties. We've seen operations that just do things from top to, from order entry to policy, where one person has their hands in a lot of the pieces of that file. So in working in an outsourced or back office scenario, you get better functionality. You get you're able to allow people to do more with less. And it eliminates a lot of staffing challenges, because oftentimes you don't need to hire a very expensive senior processor or closer. You can now, if you work in an environment such, a central environment, now all you have to do is hire someone to do order entry or post closing, etc. So it also eliminates a lot of the data duplication. It improves on capture and profit margins and customer experience, because that closer now in your office can now have better interaction with the client, with the realtor, with the builder, with the lender, versus having to do more menial tasks. It improves the profit margins dramatically too. So in a company running at scale, now instead of having these duplicated positions at every single office or every single JV office too, now they're being done from central. The other thing, the benefits here are minimizing downtime and overtime, because you allow for ebbs and flows much easier when you have an overflow partner or a centralized back office. And two, just the overhead and employee cost. Imagine this scenario is if you're running in a back office in a centralized environment, and let's say you have an independent operation and a joint venture operation. If someone in the background is doing the order entry for both entities, and then let's say they're ordering payoffs for both entities, and now they're doing post-closing work for both entities, you're paying that person, each entity gets to pay that person their pro rata cost. So it's not the sharing of employees, but that employee is producing a function, or I call it a widget. They're going to sell a widget to each entity as it's needed. You also minimize recruiting obstacles, because again, we've all been here, over the last the wave of COVID, the ups and downs and the ebbs and flows, and now the interest rates environment. So we've seen the need to scale up and then scale back down again. So whenever you're having to scale up rapidly and everyone's out looking for the same, pool and recruiting from the same pool of employees, costs get high, versus having, in a centralized, working in a centralized manner such as this, it really smooths out a lot of your costs. And the other thing too is when you're working in an environment that you can control a lot of the monitoring. You can control your productivity, your KPIs. You can allow for a lot better measurables. And again, you're going to increase revenue and profits by working in this manner, because if your JV is working, if your JV title operation is working very efficiently, it's the people involved in that operation are going to be able to maintain better relations with the clients. They're going to be able to grow and be a part of sales. Your closers not having to worry about some menial duties can actually increase their visibility to the agents and get more business that way. So there's the old adage, happy wife, happy life. In this environment, it becomes happy closer, happy client. And I think that's very important in these scenarios. Next slide. Oh, one more poll question. Take it away, Jeremy.
Yeah, one more poll question. I know we've got a little less than 10 minutes, so we'll make this one quick, not to take up too much time. Which is considered a core service? And these options were kind of pulled from the ChatGPT response. Curative efforts, survey coordination, searches, property reports. What's considered a core service among these four? All right, Aaron, we got about 2/3 that say searches. I was intrigued that ChatGPT considered curative a non-core. So
I'm not. The technology is not perfect, so I agree. We could actually core in my world. Core is some or most of the curative. When you get into actually curing title issues with corrective deeds, obtaining affidavits, doing those sorts of things. But oftentimes curative also gets lumped into ordering payoffs and surveys and HOA. So it's a little blurred there. I say you could obtain a search elsewhere. So I'm going curative, Jeremy.
Yeah, and just a quick question here, and this is less of a kind of a question. It kind of comes down to when we were talking during the pre-call of state by state what you're licensed to do. You want to add a little more commentary on what that means?
Yeah, well, I mean, it really boils down to you've got the difference of title agencies and escrow operations. So it's really east and west of the country. So title, in California, for instance, it's a separation of title and escrow. And then on East Coast, title includes escrow. So that's where your state by state really kind of differs quite a bit. And again, the challenges that we're seeing from our regulators and some of the items that Tripp had mentioned, what is it that we are required by law to do? So I run conservatively in those manners. There's a lot of different ways to set up a joint venture and an ABA. I prefer to make, again, if a regulator walks into my office, am I going to have a mild heart attack, or will I be confident that I'm doing things the right way? And I feel if you're doing things the right way, that means that you are as close resembled to a standalone title operation as humanly possible. So I know we're running short on time. I'll get through these last slides, and then Jeremy, do we leave a little time for Q&A?
Yeah, we will. And if we run a little bit over, if people want to spend a few minutes, and we can volley some questions to you. Yeah,
perfect. Yeah. So the last items to consider, or more items to consider, is just the scaling of the business. And again, if this is your independent operations, these are JV operations. But what happens in our world, sometimes you get a partner, a JV partner, who will expect you to go and grow tremendously. Whether it's usually starts off that it's a client of your own, it's someone in your city or your county that wants to have their own affiliated business. And let's all be frank here, we've got a lot of items happening right now in the world with the NAR commissions lawsuits and potential for a lot of shift and change in that world. So you may see a big demand or a lot of attention paid now for affiliated businesses, because real estate brokerages, lenders, et cetera, they may be looking for other opportunities, whether it be revenue opportunities or turnkey operations. So I believe that I'm thankful that we've had such a high turnout for this webinar, because I think it's going to be a real demand on a lot of us. And I think, at least if nothing else, if this just gives you a high level look as to what this can look like and how you can be successful in it, I hope and again, Trip and I are both available after the call as well. So it's scaling your business. It's being able to keep up with the demand from your JV client or the success of the JV. It's solving for hiring decisions, and then long-term versus short-term spike in orders, because we've definitely seen where all of a sudden, whether it be your independent operation or a JV operation, receive a spike in order count and a new client, or maybe it's a bulk REO package, or who knows what it is. You have to be able to solve for that without causing your core business to suffer, or not be able to have some sort of outsourced partner or an overflow mechanism like a back office. So the other thing is it improves efficiency. And I've always said, why, do you want to have a $20 an hour employee doing a $10 an hour task? And then are you round the clock or 8 to 5? Because the expectation is that you're round the clock. And a perfect example of that is a lot of real estate contracts are bound and executed over the weekend or on Monday. So you'll have a flood of contracts hit the desk on Monday, Tuesday, and you've got to hurry up and get those things done. Well, if you get a flood of them, you've got to be able to make sure you have the ability to get all of those orders entered into the system so you can get your searches turned around on time. So technology. Does your title production system allow for customized workflows, centralized process integration? In our world, we like to integrate tools on top of our TPS so that we can have a CRM, a business analytics tool like Tableau or Microsoft BI, or any kind of AI tools for communication. So in our world, that once we went centralized with the TPS system and all of those added tools, we were able to create a call center environment, so that we actually now can outbound call to the agent on the other side of the table. Now think about this from what Tripp said on a JV. On the JV, it's important to make an effort in getting business from the outside world. How better than calling every single agent on the other side of the table and asking for business and sending them a follow-up email or a text or whatever that may be. So those are having the proper setup and tools is hugely important in creating the proper compliant JV structure. And ultimately, core versus non-core infrastructure, what needs to be client facing, what doesn't need to be client facing, and are you structuring your back office off-site, on-site, et cetera. So next one, and this is in the slides for distribution, just to give you an example of what a workflow can look like from order entry, processing, closing, and post-closing services as to what is done at the title agency level, and then what is done by either the back office or a BPO, which is a business process outsourcing company. These are non-core title items that can be outsourced so that everything is met and done properly, and you've checked all the boxes doing core services for your JV. And last slide is how to reach me. So should you need me any further, then there you are, my QR code, and I am done at 2 p.m.
All right, wonderful. A lot of great useful information from compliance to the operations and what people on the call should be thinking about if this is a business model they want to get into. We do have a host of questions, and we're not going to get through them all, but Aaron's QR code's right there. Tripp's email is on the first slide. You can download a copy of it from the handout section. As I mentioned, you will get an email tomorrow with a link to the recording and a link to download a copy of the presentation. You'll get that tomorrow. We'll handle a few questions if you guys don't mind. If you do have to bounce for another meeting or webinar, feel free. Let's see. They're popping in fast. I can't even just keep my eyes focused on one. How do you handle an underperforming partner in the JV, Aaron? Have you experienced that? You know, or Trip, you know, if you have advice on how to get rid of a partner?
Since there's an attorney here with me, I'm going to let Trip talk about how to compliantly get rid of a non-performer.
So the big answer is you can't just get rid of them. You can't have something in your operating agreement or not that says if you don't achieve a certain level, whether it's subjective or objective, you're going to lose your ownership interest and we're going to do an automatic withdrawal. That you cannot do. So because of that, you know, how do you address those underperforming, those under-supported, and I don't like to use underperform. I'm non-supportive partners. And there's a couple of ways. I mean, and there's a couple of reasons they're not supporting you. One of those reasons might be because now they're getting more money from under the table in one of those brown paper bags, or they're getting trips, or they're getting something of value from someone else, and they're happy to take your check because they're an owner, but they're also double dipping in a sense with others. There you could have a non-compete, not really a non-compete, really what it is a restrictive covenant that says you will not accept and take anything of value from a competitor. And if you find out they are, and it's not too hard, you know, sometimes they're dumb enough to let you know. Other times, you know, other investors know what's going on. You can you can do an automatic withdrawal, put that in the agreement. There might be other reasons. They're not working full-time anymore. You can have it in the operating agreement that if they're no longer a full-time employee, or I mean full-time agent or LO or what have you, that they are automatically withdrawn. You know, certainly if you have certain value provisions, they can't commit a crime, they can't act in a way that's socially repugnant, so forth. You could have those in there as well. But what I find to be the most effective, and it's a sort of a gotcha, which is to require that the investors attend 60% of the consecutive meetings that you have. And why do I think that works? Because meeting number one, they're not performing. And they're getting a check. And there's a bulletin board that shows what their capture rate is, or what the referrals are, what the capture rate is. Number two, next meeting, same thing. And then they don't show up to the third meeting because they're embarrassed. And they don't show up to the fourth meeting, and they don't show up to the fifth meeting. They've now missed 60% of the consecutive meetings, and you just write them a check for their initial investment and say, you're automatically withdrawn, you're out of there. That's the way that's how I do it.
All right, so you have some good advice on that aspect. You didn't call it underperforming, you called it
unsupportive.
Supportive. All right. Question on the initial capital. You know, when a JV is created, does the capital need to be added at the creation of the joint venture, or can it be added over time as the JV sells shares? Hard no from Aaron.
I'm gonna speak, and then I'm gonna hope that Trip says yes. No, it has to be upfront. It cannot be financed, and it cannot be, you know, over the course, you know, using distributions of profit to pay for capitalization. Trip, yes or no?
Yeah, I mean, that's generally true. I thought I heard a little nuance at the end, which is over time as they get investors. I don't know really what that necessarily means. I can tell you that let's say you have three partners, three classes of units. You have Aaron and his title company. You have an owner of a real estate company is class 2, and class 3 are all of your agent investors. Day one, Aaron and the owner of the real estate company puts in their pro rata share of the capital, and then you will collect the rest, whatever that aggregate percentage is, from your investors, so that when you close your offering, and by the way, we didn't mention that, and I should, which is if you're bringing an agent in, that's a securities offering. If you're offering them investment opportunities, a securities offering, and you need to make sure you're compliant with the SEC regulations as well as your state blue sky laws. There is not one joint venture that I've done in the past, I can't even remember how far back, that isn't an offering to agents. You have accredited and non-accredited agents, you have to deal with that. And there's certain regulations you need to abide by. The reason you want to have an offering is not only because it's the right thing to do, but if you're going to do an offering memorandum and a subscription agreement, and it's going to describe the business and the risks and perils of investing, you don't do that, and you have a disgruntled investor, calls up the SEC, and the next thing you know, you're getting a subpoena by an SEC enforcement litigator, and you think the CFPB is bad, try dealing with an SEC lawyer. So you need to do that. But in any event, as you do that offering, and you're going to do an offering that is open for 2 months or so. Once that offering is closed, you have all your investors. Then you have all of the capital from all of your investors.
All right. We'll do two questions and call it a wrap. And I apologize. A lot of great questions submitted by the attendees. How do you calculate the amount for capitalization?
Again, to go back, it's your stand-up costs. What does that include? My fees, which is always important. That's what you have to pay first, okay? And then, licensing costs, as Aaron said, lease, software, equipment, what have you. That's your stand-up. What are you going to do day one? What do you need and what's it going to cost? And then 6 months worth, at least 6 months worth of operating costs, like you're getting orders in and you're doing it, but no money's coming in. So 6 months to cover salaries, administrative services agreement, vendors, all of those things. And then that's at a minimum. And then you have to decide whether you want to have some sort of backup capital reserve sitting there. 1, because you may need it. 2, because regulators like to see it. Sometimes, they say, well, it's not only fully capitalized, it's fully capitalized plus 5. But again, you don't have to do that, but it is something you should think about doing.
And to those left on the call, if you want to email me, I'll be happy to share, some basic pro formas that I've, that they're very boilerplate pro formas, because what you want to do is you have to back into the math. If you know out the gate you're going to start with a JV that does 30 closings a month, then more than likely there's going to be 3 employees tied to it, a licensed title agent, probably a processor, and then probably a front desk person. So you back into the math, you lead with a number of closings and revenue, and then back into the expenses and go, here's the payroll, here's the rent on the office space, here's the E&O, and here's all the P&L. We literally run through our P&L and create the P&L to create the pro forma, so that you're looking at a real standing business. And then back into the math, and you say it's going to cost me $20,000 a month of expense to run this, plus $50,000 of startup cost, whatever the number is, and then you take the formula, $20,000 a month times 6 months equals X plus, and then divided by the equity.
All right. Quick note: if you need to get CECLE, the link is in the chat box, so make sure you grab that before we wrap up. One final question is about referral business versus outside business. If the investor partner is a real estate broker / owner, would orders from the individual realtors at the brokerage be considered outside business, or would it be included in the percent of business directed by the JV?
Inside business. That's control business.
Mm-hmm.
And I just want to add one thing, because I forgot to do, sort of separate on a parallel track. There's been some discussion, some comments across the country that having agent investors or LO investors, those investors are going to run the risk of somehow someone coming in and saying they're breaching their fiduciary duty, or otherwise acting improperly towards the consumers, unfair, deceptive, abusive. First of all, if you do the disclosure, then you're not, you're letting them know, and they can choose whether or not they want to purchase a title or a title policy from your joint venture, where they know you're going to make at least some percentage or some value off of that order. And so I don't think there's any deceit there or any cover up. And, you know, there's been some arguments that I've heard out of the Mid-Atlantic area that, well, the agents will, who are investors, will call up the title agency and say, look, I know that there's this easement on the property. Don't take that off the commitment, or don't put that, or don't put that in Schedule B. You know, Aaron, what would happen if one of your investors called you and said, look, I want you to, you know, not have that on the commitment because I really want them to close on this. And if it's on there, they're not going to close.
Oh, that would go over like a sack of bricks. Aaron, can you break the law for me? Yes, sure. By all means, I'm going to put my title license at risk for you. Thank you.
So that is not going to ever happen.
No.
I mean, they may make that request, but it's never going to happen. So the consumer is never going to be harmed by that. So I don't see that there's actually this sort of split you can't split fiduciary duty. You can only have, it's just not going to happen. And that argument is really just a way in which those who don't like affiliated business and joint ventures to throw up mud and try to convince regulators that there's a problem, trying to convince the real estate commissions of every state that there's a problem, or plaintiffs counsel. It just will never win the day. And that's just, you know, that's my own, you know, colloquy there on that.
All right, yeah, thanks, Tripp. Again, apologize, we went a little bit over, but as you heard, a lot of great information on joint ventures, how to set them up compliantly, and then a look at the operations and the core, non-core services that you know that you provide or outsource. As a reminder, you'll get an email tomorrow with a link to the recording and to download the presentation. If you have any follow-up questions for the speakers, please reach out. Both contact information is in the slide deck. I do need to thank RamQuest once again for sponsoring today's webinar. Thank you, RamQuest. And that will bring us to the conclusion of today's presentation. Take care, everyone.
Thanks, everybody.
Thank you.